inside, and you will feel like
much obliged.
and then we will generate into the exchange of words.
Your Honor, for example, you can be charged, and therefore we invite you to agree with us that the Deputy Chair of LSP to add to what I just said.
I thank you, Senior Counsel. Whereas probably the Senior Counsel Ban pertinent to law. Pertinent to law. Your Honor, at this point you will note that on the question of late case, an initial report, it says must. There's a famous, shall any relevant documentary exhibits as a matter of caution and very important, especially on this first count, to confirm the age of the suspects as an administrative body to prosecute cases on behalf of the state. This is a power that the court regulates from time to time. And so with a lot of humility and respect, as my colleagues from the DPP are stating, we urge the court to regulate the conduct and the affairs of the Office of the Director of Public Prosecution. Now, Your Honor, if we may look at a cursory reading of the statement of facts, the persons before you cannot respond if a plea was to be taken. have watched, as Kenyans, persons wearing the National Police uniform called CB, vandalizing private property in the company of members of the public in Kenya. The tragedy of allowing such a charge to proceed is that even though it may be saved at the end, probably with a discontinuation or termination of the charges, prejudice will have already occurred on the persons before the court. The reading of Section 4 cannot be isolated from the definitive definition of the term terrorist act. And because we have time, limited as it is, Section 2, and I will read it, says, prejudices national security or public safety, and then proceeds to put a rider and says, and. So this charge, in the particulars, cannot be left in isolation by saying, committed a terrorist act. It has to go with the sub B, which states with an aim. Mental state, what we call mens rea, is very important because the persons before you must respond to either of the three and not all. If they had to respond to all, then in the particulars of the offense, it will have captured it that way. But, yes, that the persons before you, that the statement, the particulars of the offense cannot be read in isolation without the mental state, the mens rea, intended to do what? So that it says, and, which is carried out with an aim, so it particularizes them in three. One is to intimidate or cause fear amongst members of the public. If I am too fast, Your Honor, you could ask me to slow down. Yes. Number two, intimidating or compelling the government or international organizations to do or refrain from any act. And lastly, destabilizing religious, political, constitutional, economic, or social institutions.
This is the mens rea.
Yes, yes. So that as they are responding, if they will, the court will find that they should respond. They need to respond to a charge which is holistic. It is inclusive of what they intended to do. Now, finally, what the statement of facts states, and if the court will be minded to also look at the other count 2 and count 3, they are extremely identical to count number 1, with the exclusion of the term committed a terrorist act. Now, if the court would be minded to entertain all 3 counts, What the persons before the court will be doing would be to suffer not even double jeopardy, there's something like that. A criminal law lecturer will have to revise his manual, will be triple jeopardy. Because what it says generally is that property was damaged allegedly by the persons before you. Of great importance as I sit down, and this has not been addressed, it cannot be possible to commit acts under Porter when Article 37 exists, and the court will take judicial notice that in the charge sheet fold squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B and not included the proviso that, I will read it for the court as it retires, provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that, as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying, morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side, and I changes. At one time in this country, any person who was urging not talk much about it because we are being led by senior counsel, and he's my friend. It was meant to be a joke, but we are serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now, unlike the EPP, I mean count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as Section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the DPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Mwangi. Mr. Mwangi wants to convince you that there are two parts of that proviso that can occasion deemed not be terrorists act within the meaning of the definite of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is not to the burning, destruction, or anything. It's the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule the golden rule, when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results, to which the DPP is inviting you to. I rest my case.
Yes, Your Honor. See for the strong words by counsel, especially Mukunji here, about nonsensical stuff. I want to respond to that because I know that decision to charge is a very solid decision. And a lot of repercussions. And we have taken the decision bearing in mind the response. And especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And just to, before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
Just give him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that,
Yes,
because we are now reopening the case. Fortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules.
I understand.
Yes.
Your Honor, yes, I also
as much. Also, on the two limits much. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submission.
No, yes.
And to leave it there.
You know, I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Mukunji. We are asking.
Yes, Your Honor.
Yes,
and thank you.
Not to reopen any new issues.
Yes, thank you. Thank you to the Deputy President of the LSK.
But Your Honor, until when shall we be integrated by the
As long as you remain
right.
Just to save time, the Deputy President LSK went into the realm of new matters. And therefore, once you go to the realm of new matters, it gives a remit to the DPP to address. But I'm not going to address anyway.
Yes.
Just a sentiment. The DPP, and that is what I was saying before I was told to say, each other with a lot of professional courtesy. This is not between us, it's not between you. The matter only affects these people that are before this court.
So therefore, I do not think that needs any response.
It doesn't need. That will not be allowed. that you're not.
No.
In regard to Ms. Digger
Yes.
and Peter, of course we'll be making the same application
Yes.
if we can simply proceed with those two.
Indeed, I think even for the time.
And in those two, we will mostly be adopted.
Good. So, the state is in agreement?
We are in agreement. Your Honor.
Call out the next file. Call out the next file. So for the accused persons in E068 of 2025, you may be seated. Wale ambao wameitwa kwa kesi ya Daniel unaweza kutafuta mahali hapo katika. For those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias Sarah Wanjiko.
Yes.
They should be here.
Peter and Sarah.
Please call them. Please call them. Please, let me have the files. Sarah Wanjiko.
Six constitutional questions.
Because this is a fresh matter.
This is a fresh matter.
And we are taking quorum in this one as well.
Thank you.
So, Mr. Mjiri is the new council that is coming into this one, and Mr. Nguyenga. Yes.
Yes, there's an element of serious persecution. The officials of the DCP, Democratic, a party in coalition with several others, including those represented by County Honorable Chagwa, Gavi. That we are seeing state high-handedness. Whenever they hear the name regarding the child. I'm going to invite Council Kibe Mungai to highlight the circumstances. The state feels is not towing their kind of political line. He is haunted and charged with terrorism. And I therefore want to invite Wakili Kibe, because these two were even admitted as if they were Al-Qaeda criminals or Al-Shabaab, and counted to prison.
All the submissions that have been made by my learned colleagues so what we shall be submitting on is try to make some. Your Honor, apart from the taking off from the charges that are before this court, number one, in Kiambu, miscellaneous criminal application. One of the Sarah Wanjiko Vega was the second respondent. The Honorable Honorable Gevi Kibiru, the Chief Magistrate of Kiambu, mention of Ms. Wanjiku Vega. Had made a similar application. That case in Roiro is criminal, miscellaneous criminal case number E465 of 2025. We shall make arrangements to furnish this court and the prosecution, if they do not have already, the said two rulings. In those two rulings, Your Honor, the summary is the offenses, particularly the particulars of the offenses facing those two accused persons are exactly the offenses that has precipitated their arraignment before this court. There are in both those two rulings your honorable learned colleagues, the chief magistrates, ruled that the prosecution had not tendered the required evidence or grounds to justify their further detention. Your Honor, those two rulings under the jurisdictions of our country are appealable to the High Court by law at the instance of the prosecution. But Your Honor, the prosecution, because it is part of the executive under the Constitution, they appear under the executive chapter, only that it is supposed to be independent. They chose, instead of complying with the orders made by your honorable colleagues, they decided to deploy the anti-terrorism officers, ATPU, to invade the hallowed precincts of the court, and for all practical purposes, abduct those two accused persons for purposes of the current arraignment that is before you. Your Honor, it is unfortunate that yesterday we were unable to access our office, but since Friday, after they were abducted at Roiro and Kiambu law courts, I had an intention to bring an important authority from the House of Lords, known as Bennett versus Horseferry Roads Magistrate, a decision from England. Bennett versus Horseferry Roads Magistrate. I can't remember the other citation. but it is one of the most important decisions that could be applicable to what is happening here today. I can't remember the citation. I remember the name of the case. Bennett, B-E-N-N-E-T, versus Horsford Road's Magistrates Court. Chief Magistrates Courts like you. We shall furnish that decision as soon as we are able. Your Honor, in that decision, the basic issue was this, that Bennett had been, was somewhere in South Africa. South Africa and the United Kingdom had extradition arrangement where you could extradite persons to England. You know, but without getting Bennett from South Africa, pursuant to the extradition treaty, they decided to do a basically to get Bennett from South Africa, get him to England, and charge him. Bennett challenged his prosecution on the ground that there could be and there cannot be lawful criminal proceedings pursuant to an unlawful and unconstitutional act. There can be there is absolutely no validity. In the ultimate, the House of Lords allowed the objection, Bennett. One of the best decisions one can read, and basically saying that, my senior counsel can read this.
Yes, yes indeed, Your Honor. It's Bennett versus Horse Ferry. Horse as in horse. Here.
You can read the one.
That's very good. Your Honor, some of these passwords are for the fund.
Indeed.
Just read it.
We celebrate technology, Your Honor.
Then it was his horse ferry of magistrates and another. Horse ferry. Horse ferry is like horse and ferry.
Yeah.
Magistrates court is another. There was a 1993 All England reports at page 138 and 151 House of Lords.
Yes, my Lord. So that, you know, the basic finding by the House of Lords in allowing the motion was that this prosecution had to be prohibited, not because the state had no evidence, and not because the prosecution did not have sufficient to charge Mr. Bennett, but it needed to be stopped. Because once the prosecution and the police in England engaged in unlawful conduct and unlawfully arraigned the accused person and abetting an illegality and the violations of the rights of the accused persons in terms of the protection of law, if such a prosecution were permitted to proceed. Accordingly, Bennett was discharged, not acquitted, in order to give the prosecution a chance. To arraign him to court in accordance with the law. And so that the court's hands are not stained with the blood and the illegalities, like the acts of abduction and violence that was witnessed at Royal. Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum that that person must spend a night in their home, in their house. Otherwise, it would mean that the only choice that the magistrates at Roiro and Kiambu had was to agree with the prosecution. And if you disagree with the prosecution, we abduct within the same courts and bring somebody to committee. Is it called Kahawa or committee? This court. Kahawa. And bring somebody to anti-terrorism court.
But the nature of the confinement, you are right to call it committee.
So that
Yes, I'm going to change country.
You will add anything after me. So that, Your Honor, the issue, and it should bother the conscience of this court, because what's the image that the prosecution and the police, anti-terrorism police, are projecting? That those people that we cannot prosecute on a low threshold of law, we take them to Kahawa law courts, the anti-terrorism law courts, on the same issues, on the same charges, on the same facts. My Lord, if that were to be the case and were to be permitted, it would mean that the critical gain under the 2010 Constitution in terms of ensuring that the courts are not an executive branch and an extension of the executive arm of government would have come back. The courts in Roiro and Kiambu did act independently. And so the accused person asked me one thing. Why is the state confident that monkey business that is not possible at Roiro and Kiambu is possible before the Kahawa law courts? You know, we beseech you to make it very clear by allowing your objections, by saying that Kahawa law courts is also part of the Kenyan judiciary and will do its duty to protect the fundamental rights of Kenyans. Your Honor, my learned colleague, Senior Wamalwa, is showing to me the fact that the Judicial Service Commission actually issued a statement to condemn and object to the actions of the state and its officers that has precipitated the appearance of the accused persons before you. So that, Your Honor, from these facts, it is quite evident that the accused persons, they are armed with orders of the court, setting them free until the state has put its house in order with regard to the same facts that are before this court. Two immediate things arise. Number one, the only way to uphold the dignity and the authority of the judiciary and the courts must be by ensuring that once orders have been given, particularly against a specific group, the DPP and the police, those orders must be complied with. And a contrary action before there is full compliance. And it is easy what that compliance. Arising from that, number two, Your Honor, is that there is an obvious contempt of the court. Contempt of the court is not just contempt as committed before the court in Roiro and in Kiambu. Contempt applies. Contempt of court cuts across the entire kit and caboodle of the judiciary. So there is a contempt against this court in presenting these accused persons before you to stand trial over a matter that the prosecution chooses. We shall not go to the High Court. We shall instead take people to Kahawa. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to Kahawa. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in Kenya, my lord. Your Honor. Your Honor, the second part of these orders from Kahawa were this. The prosecution was beseeching those courts to complete investigations. That's why they needed their detention. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by the law. Is it 24A? 24A? 36A. Under 36A of the CPC. That is the legal facts as far as this matter is concerned. This is Friday. You are sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that, and the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, there must be a certain threshold of evidence that must be reached. The position in affidavit of the prosecution that is the subject matter of the ruling of 4th of July is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions. You can have them every other day, twice a week. to compare the rest here because the prosecution and the state would hear none of that. They don't even have some respect for the High Court. Because the moment those rulings were made, only the High Court could vary that position. That if you wanted, you are dissatisfied with what those magistrates say, you needed to go and convince a judge of the High Court that these are such dangerous people that your learned colleagues at Roiro and Kiambu got it wrong, and we must tame them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power, and the charges that they have preferred and want to be registered before this court constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. Because it would mean that the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Roiro and Kiambu got it wrong, get another interpretation of the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And Your Honor, we cannot have so that, Your Honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And it is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. We submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Second, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important because my learned colleagues had said something about it, just for me to say that in the definition for purposes, I believe, of Section 4, there is a proviso that is made. Yes. Yes, there is a proviso that is made that that is Section 2 actually. That with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. Your Honor, it is our submission that This proviso in sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary, because actions that are genuinely and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause. That was the distinction that was sought to be made. And I believe, as I believe we've had this discussion previously with Senior Counsel Kalonzo Musyoka, the reason was simple. Why Parliament needed this proviso to be included, that we have it in fake democracies, starting with places like Uganda, where citizens engaging in legitimate political actions end up being charged with terrorist actions, and in military courts. In this case, the closest they are getting is to come to a court that is supposed to deal with Al-Shabaab and other people dealing with dangerous things. Yona, this proviso is a logical basis for you, and I thank you for saying that you will take judicial notice of certain events, that the event of June 25, unless it can be categorized that throughout the country, that was a terrorist activity waged by Kenyan citizens across Kenya, there would be no basis to say some Kenyans who went to the streets on the same grounds committed terrorism, everybody else did not commit terrorism. The law must be rational. Because the day it ceases to be rational, it becomes impunity. You know, the related point, and which seeks to fortify Article 38, is Article 50 of the Constitution. This Article 50 of the Constitution, the ones that deals with the right to fair trial, issues to do with jurisdictions, a competent court, trial before a competent court. Your Honor, this is absolutely important for a very simple reason. Your Honor, for purposes of the trial, it must be done in an open court. Your Honor, the trial before an open court has got a very simple meaning. That an open court is a court that does not have extra security, that is easily accessible to the wananchi, and that deals with a matter of a civil nature or criminal nature, in the sense that these are law-abiding civilians of Kenya until they are found guilty. My Lord, under the Anti-Terrorism Act, the court that deals with terrorist acts in the Republic of Kenya is not a court that is truly speaking an open court. All of us, starting with myself, we were told to park my car about for facilitation, the facilities of an open court that is provided in Kahawa. Because in Kahawa, we deal with terrorists. If for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 constitution exists. You know, that point I make it with regard to two last issues that I'm about to make. Sections 42A of the CPC, sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Prevention of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Prevention of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we break, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A, sorry. We were dealing with 36A, the other side. Yona, what is it about this section? Yona, what this section is based on is because those specified into national security that despite Article 50 of the Constitution, to prosecute the case without availing of the that is an absolutely important issue because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist, you use a lower threshold. Used by JSC when people are being invited to be for higher officers. Majority of judges cite these cases as being done to the effect, Your Honor, that a good prosecutions on how it starts, not how it ends. We have submitted, this has started on that, oh, we shall sanitize this, we shall give evidence, everybody will be satisfied, let them wait. What is unconstitutional in a demonstrable manner cannot be sanitized, cannot be constitutionalized. I urge the court to accuse person until they are lawfully presented before this court. Your Honor, we are most obliged.
Questions by Mr. Kibemungai. I will allow 2 minutes.
Your Honor, I want you to address these issues together with my the people of Kenya under Article 159(1) of the Constitution. So I want you to read Article 159(2)(e). It obligates you to apply my colleagues have highlighted. Then I take you to Article 20 clause 1, Your Honor. It binds all laws of Kenya, including the Water Act, is bound by the Constitution. State officers, all state organs an orange leaf clause that way. What is the full import and implication of binding? It means if the Terrorism Act by 20 clause 1 of the Constitution, and Your Honor, if you look at 19 clause 2, what was the purpose of the Bill of Rights? It is to give full fulfillment of the potential of all individuals in Kenya. So, Your Honor, if we find a situation where people are demonstrating, and then the state actors sending goons to cause damage, you have now to separate who are the goons and who are the genuine demonstrators. Then you can now assign the offenses. But where the state has immersed itself to participate as goons, then it becomes complicated, Your Honor. And that is why we are all bound by Article 10 clause 1, and that is why we are all bound by Article 10 clause 1 and clause 2, the constitutional principles, national principles and values. Transparency, accountability, integrity. What my learned colleague have analyzed previously is that where is the integrity of the process? If these stakeholders cannot respect even the orders of the court. Your Honor, the third issue I want to raise is, in the charge sheet, they have said that it is part of the charge sheet. Your Honor, the judiciary is an independent arm. Now, if they, in the charge sheet, they are saying that a court of law was either destroyed or whatever happened to it, and you represent the judiciary, then you also have to divorce yourself from that aspect to handle this objectively, so that the independence envisaged by Article 160 clause 1 is independence even from other judicial activities which cannot interfere with this court, with this issue. So, Your Honor, we have a lot of tremendous respect for this court and for the judiciary. And that's why we are submitting that. In view of the context of these charges, clause 4 of the Constitution, it is violated. And to the extent that they violate Article 2.4 and the other constitutional provisions that we have highlighted, those charges are invalid. I want to argue only one point of fact. I want you to look at that charge sheet, Your Honor. That charge sheet for Sarah Wanjiku Itiga and the Peter Kinyanjui. Look at the stamping, just page 1. Who claims it says, Office of the DPP just received the charge sheet. Your Honor, the law has deleted the power to formulate charges. Look at the face value of the charge sheet. Look at it at the top, at the bottom. It says received. Look at that received. The DPP just received. It did not exercise its constitutional powers as contemplated by Article 157, Clause 6b, to formulate the charges or terminate. The DPP is being used like a rubber stamp. The DPP has become mechanical, and yet the DPP should be the driver and the champion of this process. So, Your Honor, look at the left side of that charge sheet. Look at the left side of that charge sheet. It is written PP. Your Honor, just let us interrogate that one. PP. Who is PP? People are known by their names. People are known by their names. So we don't want these jobs. We want people to take responsibility. If a prosecutor is signing a charge sheet, the condition is name and the rank of the prosecutor. On that ground alone, we don't need to be academic. This is not rocket science. On that ground alone of that charge sheet, the face of it, AA and PP. We don't know who AA is. So he cannot be held into account. So that if there is a problem, we can pursue him in civil proceedings to get to recover damages. So we don't know who AA is, and I know I have tremendous respect for the DPP. Because my wife has worked as a DPP, so I have tremendous respect. So I am saying this from the bottom of my heart, that they need to be accountable. And that's what we are demanding. Yes. Yes. Your Honor, for that, I think I've added some time.
Your Honor, from the law side of Kenya, allow me to start by saying that we need to adopt our submissions, especially the points of law in regards to the propriety of the charges facing the two subjects before the court in totality, so that we save on time. In fact, for the record, the submissions are in reference to E68 of 2025. Yes. Your Honor, the first is our submission is in reference to the files that we just brought before me. I'm adopting, yes. Your Honor, the persons before you are currently enjoying orders of this court in reference to their liberty. This is a person to miscellaneous criminal application E290 of 2025 in the Chief Magistrate Court at Kiambu. For purposes of record, by the two. One is arson, contrary to section 332 of the Penal Code. The second one is malicious damage to property. The third one is robbery with violence. Nonetheless, Your Honor, this is a court file. I am very sure that the court has judicial notice, so it's a public document. All I am trying to say, and in the interest of time, is that the offenses that the persons before you had allegedly been brought before the Kiambu court on a miscellaneous to have custody of them were serious offenses than the offenses that they have allegedly been brought before you for plea taking today. And I am not in any way saying that offenses related to water are not serious. But the ones I have cited carry mandatory sentences that are extremely punitive. Your colleagues in Kiambu agreed in those offenses with the respondents and afforded them bail terms. I am reading the National Police Service standing orders at chapter 15. This is at section 2 on detention of arrested persons. Section 2(2)(d). The import of this section, Your Honor, is to guarantee the enjoyment of the fundamental right to bail and bond of a person by a police officer. What the masked and hooded men and women wearing the Kenyan National Police Service insignia who whisked away the truth failed to appreciate on that day is that the law was not on their side. before arresting such a person, they ought to have made an apprehension report in section 37 of the CPC to yourself or any other magistrate within the definition of the Chief Magistrates Act. To have the person remanded. That was not done. Your Honor, in Law Society of Kenya and 5 others, I am buttressing what Mr. Kibe Mungai was saying. In Law Society of Kenya and 5 others versus Kithinji and 5 others. This is a constitutional petition E. Your elder brother, Justice Momuye, your elder brother, 373 of 2024, person and or on any instrument or vehicle that they use while conducting law. Was not an arrest. In all definitions, it was an abduction. The courts of law must continue to function objectively to safeguard at liberty, will be at a peril. As I wind up, because I also don't want my colleague, Mr. Ndegwanjiru, to say anything, probably to, again, from the Law Society, we advise the Office of the Director of Public Prosecution to reconsider that decision. Your Honor, from the Law Society, we are extremely grateful for your candor. I know you've been seated there for a long time. Some of us have walked out and have walked in. As a final submission, as you conclude to determine this matter, we thank you and we wish for your...
This is a section which seeks to teeter the trial of offenses where they have happened. They being officials of a national political party and courtesy of the submission by the counsels for the defense led by Senior Counsel Dr. Kalonzo Musyoka, that may pop out is, could this be forum shopping? Your Honor, there is need for this court to address that. We don't know whether from here they will be charged in Garissa or Mombasa. So that kind of nomadism need to be discussed. There's another one, Limuru, very near. And my appreciation of a court is not the courtroom. I was practicing when another room was arranged for that. So, Your Honor, I leave it at that.
Your Honor, before counsel rests, maybe you should clarify the case numbers for which the accused person were charged.
I'm giving you the answer that that is already on the record.
Most of that. You know, whenever the DPP stands on their feet or adrenal in lashes.
And you are concluding.
So I was at the tail end.
Thank you.
Yesterday, he was, a tear gas canister was thrown in the cell where he was held in. By an officer.
Only 1 minute, Your Honor.
Yes, one
Just
minute.
where a police officer shot in broad daylight during protest a man named Boniface Kariuki. The circumstances of that shooting and killing were as they were on the 25th of June. That was 30th of May, sorry. But that's during the demonstration for Albert Ojwang. But that officer was not brought before any anti-terrorism court. Yet the circumstances fits and suits the definitions under Section 2 of the Terrorism Act. It tells you there is a double standard in the manner in which the DPP is executing these functions. Finally, in summary, the doctrine of exemption created by Section 2, which our land senior counsel, His Excellency Dr. Kalonzo, referred to, exempting protests from acts of terrorism, underscores the necessity of distinguishing between peaceful expressions and violent acts, thereby upholding democratic principles and protecting, therefore would mean that the church is stinking to the high heavens, and that this
our forum from the Law Society has increased. We have Mr. Brian Musyoka.
Thank you, Your Honor. We'll listening to submissions by the defense. And before proceeding to make submissions, I'd like to highlight, I think, one issue that has become a contest in these matters. Peter Kinyanjui and Sarah Wanjiku before this court are facing other Sejiko before this court are facing other Section 2B, where the law provides an exception under Article 37, an exception under Article 37. That we agree there was a legal protest, Your Honor. That we agree there was a legal protest, Your Honor, that was ongoing. What we do not agree with them is the road transport was not being used, Your Honor, the public transport system, in pursuance of legal protest, Your Honor, and notices had been. The Act goes on and says, within the meaning of this definition, as long as goes on and says, within the meaning of this definition, as long as the Act, now this is the part that the court should look at. In our charge sheet, we are saying that the harm is not intended to resort to any harms referred as to paragraph A1.4. You will see that any act that happens under the same provisions is exempted from a peaceful, protected protest. Now the act of terrorism, in a very plain understanding, for breaking it down to everyone to understand, it only transits to act once you cross the line under Article 37. The Article 37 is protected, and you are acting, and the demonstration started under Article 37. They crossed that line, and their action resorted to paragraph A1 to 4. Then terrorism charges began. Terrorism acts began. And from the word go, counsel for the defense was submitting from the bar. You've been given nothing. Nothing to show that indeed there were abductions,
Your Honor, politely, I think this is something in the public domain.
Your Honor, what I was saying before was disrupted by the council. An abduction is a legal term that was taken by the defense in support of an allegation that there was an abduction that transpired when the two on section 37 of the CPC. But allow me to take you back to section 21 so that we can move. You know, section 21 gives the police the power to arrest. And the arrest at touching. Once you are touched, and then it goes up to confinement. You know, from confinement, then it gets to all means necessary. And from necessary, and this depends with the reaction of the person being arrested. You know, the law says that no greater force than necessary may be exercised. So there was an escalation from touch, but there was no all excess force that was used that was necessary, and that is our submission. And if indeed there was, now that becomes subject to trial. The defense, or people alleging that more force than necessary were used, then the burden shifts to them to prove that indeed more force used than was necessary. So abduction, we submit, is a legal term that has legal interpretation, and what transpired is not an abduction, but an arrest. They've equally, submitted that there were other charges that were facing the two accused persons before this court. With all due respect to counsel, there are no charges that were before any other court in the Republic of Kenya. What they are quoting to you are miscellaneous applications for custodial orders pending charging before any court of law. And that is why they've not presented any charge sheets before this court, because indeed there was none. If they are candid enough, they would admit that what was there was a miscellaneous application. And after a decision was made, that time, a decision was made to charge with terrorism, and they were therefore now transferred from to try terrorism from any part of this country. And the charges before you, Your Honor, brings the accused person at the scope of this court. Let me go to section 36, Your Honor, of the same CPC. It provides for detention, gives the police the power to detain people arrested without warrants. Section 36 provides for detention of persons arrested without warrant. Immediately after section 36, you've been told about section 37, that they are supposed to report the apprehension to a magistrate. You see, the selective reading of the law of the OCS of the police station have, the responsibility to report that apprehension to the nearest court, Your Honor. And on 4th of July 2025, date of the arrest, which was on Friday, past working hours, the Constitution says that this apprehension, and if the 24 hours falls outside the working hours, then they are taken before the court at the end, before the end of the next court sitting day. On Monday, the 7th of July, they were arraigned before this court, and the court was informed of the arrest and the matter after arraignment. There is no impropriety, illegality, or abduction. Consequently, from the arguments of section 36, 37, and the Constitution, other that having been said, Your Honor, the two individuals before this court, you're told that they are party leaders. We are not here because they are party leaders, Your Honor. We are here because a charge has been approved. And the jurisdiction of terrorism charges can say that they are being profiled before a court that is not sufficiently equipped to give that decision, since the decision, the ODPP decision to charge at a portal. Your Honor, in legal terms, what they are telling you is, can this decision be reviewed judicially? And if that is so, if that is what they're asking, Your Honor, the court that is equipped to deal and to check any excesses in terms of whether the decision was appropriate or not is the High Court on judicial review. Therefore, any argument as to whether plea will be taken or not, Your Honor, whether the charges are appropriate or not, cannot be legally and sufficiently be handled before this court. And a decision to charge having been made, then the plea, the most appropriate lesson to take is to allow, Your Honor, the plea to be taken. The remedy under judicial review does not subsist the plea taking until the trial is completed. Your Honor, there are some few issues that have been raised about Ufeni nyote, nyinyi nyote, such sentiments, Your Honor. And unfortunately, these are sentiments for the defense. We do not know whether they intend to swear any affidavit to that effect, since information from the bar, a legal force of law, unless it's submission. That information has to be communicated in a format known as an affidavit, and not through hearsay from the true defense counsel, but by the person who was addressed. And I'm very concerned that counsel can submit as such. If indeed there was a police officer who did that, that is an illegality that we cannot even entertain. Let them follow the right channels, so that we split politics from law and law from politics. Finally, as I sit down, legally, Your Honor, there is nothing presented by the defense, whether constitutionally or through submission, that has raised reasonable grounds, Your Honor, to stop plea taking. The issue as to whether these are the appropriate charges or other appropriate charges should be preferred, Your Honor, is not an issue that can bar plea taking. And we wish the court to find that the charges are before this court. These people have been registered appropriately within 24 hours and clear may be taken. I have two colleagues, Your Honor.
Your Honor, just to buttress the point of my senior colleague, and I will submit on the issues in the application that is being made by my senior counsel, Mr. Kibe, on the issues of whether the rights of the arrested persons were infringed when they were being arrested. Your Honor, these issues would have been raised under Article 89 of the Constitution. And so, counsel should be telling you that his clients were denied counsel, or they were not brought before this court within the 24 hours rule as stipulated by the Constitution, or they were denied counsel, or other issues that are outlined in Article 49 of the Constitution. Those are not issues that have been brought before you. And if they were to be brought before you, or as counsel has said that they were abducted and not arrested, this court, then the question should be, can those answers be answered? But can those questions be answered by this court? And I say, interpretation of law, especially with regards to breach of rights, fundamental rights under the Constitution, can only be interpreted by the High Court. You look at Article 165, the Constitution, sub-article, that is B, it speaks to the jurisdiction of the High Court and says jurisdiction to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. This is to say, this court has no jurisdiction to entertain the application by counsel to determine a question of infringement of the rights of the arrested persons. And why are we saying so? Because when counsel alleges these matters from the bar, are we allowed to cross-examine him? Because these are issues that he brings from the bar. Can we put him on the dock to cross-examine him? So this question is a question of trial, requires evidence, requires affidavits, requires to ask to be given an opportunity to respond, because now the blame is on the police officers who are allegedly abducted these individuals. Therefore, Your Honor, we are just saying simply, the issues that are before you are very simple, and they have very, very simple answers. But one, on the issue of whether the charges are proper, we have already submitted, and our position is, yes, they are properly brought before this court. And on the issues of whether the accused persons are properly presented before you, those are issues that cannot be litigated here. They have a recourse elsewhere. The accused persons are before you, and they are properly presented before you. And we have supplied them with the charge sheet. And Your Honor, you should allow us, this court should allow us to proceed and the accused person take plea.
Your Honor, I wish to adopt the submissions of my senior and my colleague. I believe we have given sufficient grounds as to why we are charging with these charges, Your Honor. We also submit that this is the proper, we use the proper channel, this is the proper court to present these charges. Your Honor. We do acknowledge Article 37, and we do respect it, Your Honor. The issue at hand is whether there was a commission of a terrorist act. We wish for the court to look at section 2A, 1 to 4 of the Prevention of Terrorism Act, which provides to when a protest, to what actions can lead to a protest being regarded as a commission of a terrorist act. From the particulars, it's quite clear, we've articulated all of them. There was destruction of property and among other issues. We submit that the charges are proper. The elements of the charge have been articulated in the particulars of the offense. We say that you do allow us to proceed in taking, and the issues of evidence can be dealt with later, where we can be able to show that we were able to use the decision to charge guidelines to make these decisions.
Your Honor, before I speak to the defense, I would also wish to raise a concern. As we are proceeding and making legal arguments before this court, one of the defense counsel, Mr. Mukunji, advocate, in his Twitter handle, @GeroAdvocate, was busy texting our names on social media and generating a debate, and the title, Your Honor, of the said Twitter is weaponization at its best. He proceeds to say that 3 counsel appearing for the state are weaponizing this process. Your Honor, for me, I take that as an incitement, and I do not take it kindly. And this counsel should be reprimanded, Your Honor. And it should be one also that should he incite public to generate any reaction, then he should be answerable, and the court should, and the court should take notice of that.
Can you just allow the counsel?
Yes.
The counsel to
And Your Honor, this is a post that was done at 11:12.
You know, am I required to respond?
And also amended and reposted again.
Yes, Your Honor, I do not believe that those are issues under the trial. Yes, I did it in exercise of my rights. Counsel stated their names in the glare of the public and the media. And if I am right, Your Honor, I would wish to restate the said names so that the record may read correctly. Yes, I think we are dealing with Ms. Wangoi, Ms. Mashira, and Mr. Kamau as the counsel appealing for the BPP. If I am wrong, Your Honor, then you can correct the record so that I can edit my tweet.
What about weaponization? Just read the entire Twitter.
Yes, it's there. It's not an interpretation. You can bring an affidavit and respond to it appropriately.
You're not from the Law Society. From the Law Society, this is maybe an issue that they can deal with internally in the Law Society. Counsel for DPP has alleged severally that you don't have jurisdiction on everything, probably including this. We can deal with it from an MSK level so that we move on. And it's something that can be resolved.
I hear you, counsel. Mr. Kabata.
Yes.
Now, I do agree that the statements that have been made by counsel have been brought to the court's attention, and Mr. Bashir, you highlighted them. I I think, not for the court to take any particular action against this injury, but the court to note that that has been done.
Very well.
And that therefore, Mr. Mashira, you have a statement which is a platform, and for what that is worth, I think you will know how to pursue that.
Most of it.
Just to say that again, that we the court makes a determination on this question. Why don't we allow the process to run its course? Thank you. So that we don't include
Absolutely.
Yes. Your Honor, I wish to agree with my learned counsel from the DPP that the term abduction is a legal term that ought to be used in the technical sense that it means, and particularly for purposes of judicial proceedings. Your Honor, articles, no section, Your Honor, under section 250, the word abduction, or the offense of abduction, is it induces any persons to come from any place, is said to abduct that person. Any person who by force compels, that's the first part, or by deceitful means induces any persons to go from any place, abduct that person. That is section 256. In the circumstances of this case, we are relying on the first part, the use of force, which was witnessed during the so-called rearrest of the accused persons before you. There was force used to get them from the courts, and now to present them before this court. Your Honor, we have gone, the definition, I believe my learned friend from the LSA, the DP, Maura Kabata, defined to the court how an arrest should be conducted and pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail, pursuant to court orders, they were grabbed from the registry while processing bail. clearly. This was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there's nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That they were grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Horsferry Road's magistrates court, the issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, and that order was not there, the court actually said, we cannot allow people to be tried in English courts, people who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Mandera, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. And the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justified the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Horsferry versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, arson, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is what are the offenses against this man and woman. The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions to charge. The High Court. It is a personal decision that you must be satisfied that you have jurisdiction. Jurisdiction can be complicated. But if the adversary was not in Europe, where Degwajiro was killed, it clearly cannot, you cannot say that you have a valid charge. Let us wait for the DPP and the police to give us evidence. Call it a rearrest. You know, this is a mischief rule. The court, you know, this is a mischief rule. The court must go to the mischief rule. The last 2 points of the Constitution is this. To the mischief rule. The last 2 points of the Constitution is this. About your authority, that provisions of law. About your authority, that provisions of law. Article 21 had been cited by my learned colleague Mr. Ondieki, 21 and 4 of the Constitution. Under 21 and 4 of the Constitution deals with the issue of application of the Bill of Rights. 21 says the Bill of Rights apply to all and binds all state organs, and 21 says the Bill of Rights apply to all and binds all state organs and all persons. Your Honor, you are a state officer and you are required to observe it. But more importantly, 20 Sabbatical 4 is very clear. In interpreting the Bill of Rights, a court, a tribunal, or other. And finally, Article 23 of the Constitution. Article 23 of the Constitution, Parliament shall enact legislations to give original jurisdiction in appropriate cases to subordinate courts to hear and determine applications for redress of a denial, violation, or a threat to a fundamental rights in the bill. Is exercised directly. It doesn't require any law. So you apply that authority as you understand it. So we are perfectly entitled to say very clear, to protect certain people, is that terrorists across the world, not just in Kenya, are persons who are hated, it is much bigger than the prosecution is making out to be. Because to permit this, it would literally allow the 4,000, 5,000 people that we've been told have so far been arrested to be tried as terrorists. Your Honor, Kenya will cease to be a constitutional democracy if such a precedent were to be set. We have made the objections here. I urge that you uphold the constitutions. You are most obliged.
Your Honor, we have to bring this to its useful conclusion. We thank you for your patience. Thank you. Very briefly, in summation,
Section 2 of the Prevention of Terrorism Act number 30, 2022, and the proviso thereof. We've been addressed extensively on this, and is exercising their rights under Article 37 cannot be charged under the Prevention of Terrorism Act. The only thing in that proviso is if that is proven, then citizens are not covered under that proviso. But our submission is there's no such intention. Therefore, is actually very clear. It is actually unassailable, and we urge you inappropriate. And for the avoidance of doubt, Your Honor, the Judicial Service Commission issued a very clear doubt. By the way, the chairperson of the Judicial Service Commission is the Chief Justice.
Your Honor, perhaps with your permission,
I do not expect that all the time
it's
trying
okay,
to do
but
these things.
that was not an issue that we did a rejoinder if. There was no statement that we went through. So this is a new issue that...
it's not a new issue, it's been referred to, Your Honor.
We need your ruling.
It's not a new
Your
issue.
Honor, with your kind permission and with the permission of my learned senior,
Can I be addressed by the two so that we can quickly deal with
if I can help refresh your memory, Your Honor. I raised the objection.
My memory is quite fresh.
Yes.
No, I'm saying the reading. He's now going to the reading.
No, it's just the same. The substance is not changed. It's just for the avoidance of doubt.
No, he's reading, Your Honor. Is it necessary?
The chairperson of the Judicial Service Commission and your officers of court is the Chief Justice herself. And this statement, the rearrest of an accused person within the precinct of the Ruiru Law Courts on Friday, 4th July 2025. The facts indicate that the accused had been released on the constitutional mandate of the police to enforce the law and apprehend the suspects. Use of fire and dignity of the judiciary. Courts are sacred spaces of constitutional adjudication. Okaya, CBS, Secretary, Judicial Service Commission. The date of the statement, Your Honor, argument about the impropriety of the rearrest. I personally like to call it simply abduction, and therefore, Your Honor, you historic because if you decide that the two accused persons, I mean, they were yet to take a plea because you object to that. In fact, we are calling on Your Honor to discharge them unconditionally, as happened in the case of Rose and Jerry just the other day. So we're going to argue that, the charges have been preferred, the ODPP has done this, and I appeared in court along with Chief Justice Emeritus, because what Rose and Jerry did was just to accept, to give our opinion with regard to public participation matter that the committee in Parliament dealing with finance had put out to the public. And then she was apprehended, actually abducted. Rose and Jerry today is a free citizen. We want to urge you to use the authority of this court so that you will enter the annals of history as one judicial officer who chose to stand for the constitution of this country. And various aspects have been addressed. Article 20 of the Constitution, for example, which binds all state actors to observe the Bill of Rights. International Bill of Rights, which is part of our domestic law now.
Just a quick question, Council.
Yes.
If I were to make my decision in order to enter the annals of history,
yes,
would that be making a decision for personal interest?
Yes. No, indeed not. Indeed not. You will. I'll guide you on that one. It is simply that you apply your mind to the conversation that has appeared before you, that has been offered before you, and to be able to apply the law judiciously, because that is what we're asking you to do. But in so doing, you will also be capturing the moment in our country's history. Right now, judicial notice should be taken of the fact that we are a country at a crossroads, and all of us have to do something to save it. We are simply saying we object to the practice of the Director of Public Prosecutions arresting Kenyans, bringing them to this court, and charge them under the Terrorism Act. That is intimidation of a sort that cannot be tolerated. In fact, it is inflaming of the country. Your Honor, I want to say that these two persons